Good morning. Thanks for joining us today for this installment of the Pro Bono Partnership of Atlanta's monthly webcast series. My name is Surisha Ganta, and I'm an attorney with the partnership. Today, we're excited to have with us Tony Igbenova and Ami Rodriguez, two very fantastic volunteers and attorneys right here in Atlanta who specialize in privacy. They'll be talking to us today about data breach prevention, detection, and response. And before they go into the substance of today's topic, I want to tell you, our audience, a little bit about Pro Bono Partnership of Atlanta first. Our mission is to provide free legal assistance to community-based nonprofits that serve low-income or disadvantaged individuals. We provide these services by matching eligible volunteers within organizations here in Atlanta, both in-house counsel and law firm attorneys with nonprofits to assist them with their business law matters. In order to be a client of PBPA, you just need to apply, and our requirements are that our clients be 501c3 nonprofits located in Metro Atlanta or serving Metro Atlanta, that serve low-income or disadvantaged individuals, and our clients are otherwise unable to afford legal services. We also have available on our website a wealth of resources for any interested nonprofit. They're available for free, and we have on there articles, webcasts, podcasts, and even in normal times, we have live presentations, in-person workshops. So we hope to start being able to offer those again sometime in the upcoming year. And if you're interested in learning more about the organization or in applying to be a client, please email us at rla@pbpatl.org. And a quick disclaimer about today's information, because we're lawyers and we like to have disclaimers and clarification. The information that Ami and Tony are going to be covering today is just general information. It is not specific legal counsel for your organization. So if you have specific questions, please reach out to an attorney. And today's information, today's presentation is copyrighted. And now I will hand over the mic to Ami and Tony. Thank you, ladies.
Awesome, thank you. So we're going to dive right into this, and we're going into the considerations before a security breach. These are the three main things that you should consider. First of all, what's the incident? Is this a security breach or is it simply a security incident? Also, identifying a response team, having that core group of people, also doing your dry runs and your tabletop exercises. And so we'll dive into each one of these topics as we go into the slides. What's the incident? So all security breaches are incidents, but not all incidents are security breaches. When is a security breach considered, when is a security incident considered a breach will depend upon the state law. So you'll have to look at the text of the breach notification for the states in which you have consumers, where your data subject's located in mainly. Look at the letter of the law to determine whether a breach truly exists. For Georgia, for instance, our breach notification law is OCGA 10-1-912. And this gives you the information for notifications that are required upon a security breach. Now we're looking into identifying a response team. The goal here is to have a core team of individuals who are dedicated and trained and prepared to handle these incidents. These groups will be your go-to people in the event of a breach. And it's really important to have a team established prior to a breach. You don't want to start circling a team during a breach. It will cause a lot of confusion, chaos, and disorganization. So the goal is to have that go-to people. And these individuals can be comprised of your CPO, your CISO, internal comms, IT, customer service, or even HR. However, if your organization doesn't have any of these individuals, feel free to be flexible. The goal here is to have a core team that's trained and that's prepared to handle these type of security breach incidents as they come up. Tabletop exercise is extremely important. Even if you have a team, you have policies and procedures in place, if there's no practice based on real life scenarios, based on the type of data that the organization holds, the size of individuals, the types of team and departments that are compromised within the organization, it will be an issue. So the goal of the tabletop exercises is to make sure that everyone is on the same page. Does everyone know who to contact in the event of the breach? Who is talking to regulators? Who is speaking out publicly? What are the specific policies and procedures? Does everyone understand? Do employees understand as well? Also, during tabletop exercises is a good time to discuss privilege. What type of information do you not want to be disclosed? That's something you should sit with counsel to discuss as well. In addition to identifying your crown jewels, think about what's the important data that's used within the organization to keep operations going and how to protect that data in the event of a breach.
Tony walked through some of the steps that need to be taken before there is an incident, before your organization has to figure out what to do next. So it is very important, of course, to have at least a process where you know who to go to, who does what, and of course, go through test scenarios. Preparation is always key. Sometimes you may have an incident that is new, that you haven't prepared for, but at least you have the roles and you know who is designated to do what. So let's talk about now the bad thing has happened. There is an incident, it may be a security breach. What are the next steps? 3 very simple steps. First, stop the source of vulnerability. If it's a digital vulnerability, figure out what do you need to do to stop the bleed, as we call it. Are there certain IT upgrades or patching, or do you need to shut off the system in order to stop the vulnerability? Is it
Audience, please bear with us a minute. It looks like we're having a technical difficulty.
I'll take over for Ami till she has a chance to return. So we're also talking about not panicking as well. And this is where we're assessing the details of the breach. Finally, seek counsel. So in stopping the source of the vulnerability, we're looking for where the breach actually exists. And we're looking to stop the breach. Before you can do anything else, we want to make sure that we're preventing harm to our consumers or our employees. And we're stopping the source of the vulnerability through identifying it and making sure we have the security features in place to prevent what's happening. And then in times of non-technical glitches, where there's a theft of files or a misplacement of documents, the goal is to understand and properly document all the known factors. Even though it's a paper breach versus a technical breach, each detail is still important in the event of having to notify relevant regulators as well as consumers. Apologize for that. And so next you want to seek counsel. Get counsel involved in order to help you with your breach notification requirements or even assessing whether a breach exists in the first place. But our slides seem to be out of order. So prior to that would be not panicking. So this is where we're assessing the who, the what, the where, the when, and the why, as well as the how. So who is affected by the breach? Who are the impacted parties? Has employee data been breached via HR, or is this customer data that's been breached? Also, what type of data has been breached? The type of data will give us a level or a way to weigh how sensitive this information is. So for instance, if email addresses have been breached, that's less significant as social security information, whether that has been breached. So we'll need to understand the specific type of data elements that have been breached, as well as where. We need to understand what environments have been breached, and that's the only way to stop the vulnerability as discussed before. When the breach happened is also extremely important. That will be a question that regulators will want to know, and you'll need to provide an accurate date. If you provide an inaccurate date, that can actually increase your liability. So when did the breach happen? Make sure you understand specifically when the breach took place. And Ami is back on, so I'll hand it over to her.
The biggest irony is when I say don't panic and of course my screen freezes. Going off on when did this happen, one of the things that you'll notice in the black box is sometimes you're not aware of the facts as they come in. The facts may still be rolling in. This is where it's really important to engage counsel to help with understanding when do your notification obligations begin? Do you have a full set of facts in order to even inform individuals and to inform regulators? It is common sometimes to go back to a state AG, for example, and say, hey, we actually have more individuals we have identified. It is usually not advised to then go back to the same individual and say, in addition to this information that was breached, we have found more information regarding you. This is where a lawyer can help you navigate what is the best message you want your organization to send. Typically during this time, and again, don't panic, but during this time, everyone is on edge trying to figure out how do we demonstrate responsibility and transparency. Understanding what your goals are at the end of this breach, how to get through, and what resources you have available will also guide how you address the when and how you address any notifications. Sometimes a why as to what vulnerability or error triggered the breach is not going to be immediately available. Sometimes you may need to wait and investigate and show that you did your due diligence to find out what exactly happened. And of course, once you find out the why, what did you do to stop the bleed or to remediate or at least prevent further harm? How to fix the breach? Sometimes you can't unring a bell. Sometimes the information is out. So what is the remedy for affected groups? Is it credit monitoring? Sometimes it is also a note that says, please be aware of your passwords. Here is what we think may or may not have happened. Sometimes you don't know all the facts, and you have to communicate that in a gentle way to the people whose information may be compromised or potentially impacted. It's very common to say, in terms of a remedy, you have to be vigilant with your information. Unfortunately, a lot of people use the same passwords across databases. People may also not be very careful with their information. Sometimes you may also get calls from from individuals who have been impacted saying, how did this happen? What happened? What are you doing to protect this? This is normal. You may only get one or two of these calls. You may get a handful. You should also be prepared as part of your remedy to have a number or an email address that people can call to ask questions. Next slide, Tony. I think you're on mute, Tony.
Tony, I'm not able to hear you.
Some of the considerations after a breach, 2 things to consider. Are operations back to normal? And do you need to send breach notifications? And if the black letter law, according to counsel, does not say you do need to notify individuals or regulators, do you maybe want to send a courtesy notification to the individuals or to the estate AG or other regulator? So our operations back to normal. Sometimes the hardest part is knowing, when are you done? When are you done investigating? When are you done doing with your due diligence? Sometimes you may just have to, there's what's called, when you convene your team of people who are slated to respond. Sometimes you have done all you can. And that's where talking to counsel about, have you taken the necessary measures? Have you demonstrated to an objective third party that you have done, given your organization size, given your resources, given the type of information impacted, have you taken the necessary steps? This answer is going to vary from situation to situation, and it's also going to depend on the size of the organization. When you resume operations as per normal, this is not going to be a binary resumption. It's not going to be suddenly something comes off and then you start the next day and everything's fine. It's going to be a gradual trickle back to normal as people need to be released from the core team, deciding what the response is. And so there may be a bit, you may also have to plan with this core team. There will be times where an individual may have to be maybe have to do their normal job while also joining meetings over what is our response? How are we handling this incident? Breaches do not last forever. Starting early with identifying the source, running through tabletops, make the transition from breach to normal operations much easier, because you will have had at least anticipated what your response and resources are.
So breach notifications are courtesy notifications. As Ami mentioned, once the threats have been settled and a plan of action has been drafted and you've worked with counsel, you want to look on whether you're required to give these notifications. As we discussed earlier, whether it's a breach will depend on the letter of the law. So per the letter of the law, if the incident is considered a security breach, you'll have some required disclosures, whether to regulators and to consumers. However, that varies state by state, and you'll have to look at the law. Courtesy notifications, however, are scenarios where the incident is not considered a security breach. And so you are not required, depending on the law, to give certain notifications to regulators or consumers. However, you can give a courtesy notification as a good faith notification. And this can help you in the event of a real security breach if you have one down the line, because now regulators do not see your organization as malicious. And regulators also know that your organization takes the active good faith steps to notify and remedy affected parties, as well as to notify relevant regulators. So at a high level, the checklist for security breaches is identifying whether it is a security breach, looking at the letter of the law. Is this an incident or is this a security breach? Also identifying a response team. You want to have that core group of individuals who, in the event of a breach, are prepared and are trained and know what steps to take in order to cause less chaos, disorganization, or confusion. You also want to practice tabletop exercises. The goal is to simulate real life breaches. What happens if we have a ransomware attack? What happens if an employee clicks open a phishing email? Who communicates what to whom? That is what those practices will allow you. And it will also allow you the chance to test your policies and procedures to see whether they're truly efficient or to see whether they need to be updated. Stopping the source of the vulnerability, extremely important. If you don't stop the source of the vulnerability, the harm keeps on happening. And the greater the harm, the more liability you can have at the end. The goal is to limit liability. And do not panic. Assess the facts. The who, the what, the when, the where, and the how. We need to understand the breach in order to properly remedy the breach and limit the harm, as well as potentially give notification to consumers and regulators. You have to seek counsel. Seeking counsel can help you bridge the gap of your knowledge where you're not sure if it's a breach or not. You're not sure if you need to give notifications or not. That's where counsel can really step in to help you interpret the letter of the law. Also, we're looking at whether operations are back to normal. We're looking at whether the leakage has been stopped. We're looking at whether the breach, you've informed the necessary parties, whether you've remedied the necessary parties, and even whether you've updated your your policies and procedures that relates to breach handling. And then you're rendering the necessary notifications, whether required by law or whether courtesy. And we're open to your questions if you have any.
Thank you, ladies. One question that I wanted to ask that came up earlier was, how often should these tabletop exercises happen where where within an organization they kind of sit down and pre-identify these concerns?
That's a great question. I typically recommend anywhere between once a year to 18 months, especially if you have any personnel changes, if you have new people coming into different roles, or if the information in the organization changes. A year typically catches that. Sometimes you don't have the capacity, but even within 18 months, we'll ensure that everyone, that people understand what their roles might be.
I agree, definitely.
Okay, and also, you guys had talked about initially incidences versus breaches. Is there any sort of cheat sheet or list for organizations to know quickly, or to share with even within an organization of, okay, this is what would be considered incident, this is what's an actual breach?
So that would really depend on the state law. We would really need to understand what state, your data subjects are in order to determine whether it's a breach or not. So I would recommend looking at where your consumers are based and then having your counsel create those cheat sheets for those areas in order for you to kind of have that go-to sheet for Georgia. This is the OCGA we're looking at, and in Georgia, these events are considered a breach. And so you kind of can compile that on a sheet as well as for another state. And I think that is very helpful.
Very quick and dirty is if there is name, email address, social security number, financial information, address. That's going to usually trigger checking whether or not this rises to the threshold of a breach. It may not. Again, depending on the state law, that anything, those categories, again, name, address, government identifier, social security number, financial information, health information, that's usually your trigger point to go check.
And we have a question from an audience member that kind of relates back to notification. It's the charity has a breach of a donor base, and those donors are in states all over the country. How do they know where to start, considering that they're in multiple states?
You start by 1, don't panic. 2, engage counsel, because there are different notification thresholds for each state, and you still have to assess what are your facts. What actually was compromised in how many states? Who are the affected individuals? That takes time. Again, don't panic, engage counsel.
And a lot of our clients work with third parties to manage their donor bases and to collect the donations. And that's where a lot of the information is. If that information is all collected by a third party, then does the nonprofit organization need to worry if that third party had a donor breach or had a data breach? Sorry.
Depending on your consumers, I would say yes. And Regardless, it's always a good step to take to make sure you're involved in your third party's processing because they're attached to you. And a breach with the third party where you're not properly monitoring them can also cause you reputational harm, which can potentially, affect your organization. So I would definitely say that to monitor your third party's processing, and in the event of breach, to work with them to make sure that they're taking the accurate steps to remedy the breach and to notify necessary parties if need be, if it's considered a security breach.
Okay, well, it looks like that is all the questions that we have for today. Thank you so much for providing this incredibly valuable information, especially as many workforces continue to be virtual and are transmitting data over the internet so much more now than ever before. Thank you for your time and for sharing your expertise with us. It looks like we have one person typing a question, so we'll give them an opportunity to ask their question. And if not, we can follow up on it afterwards. But Tony and Ami, thank you so much for joining us today. And to our audience, thanks for joining in.
Thank you.
Have a good day.
Our audience, thank you for your patience and humor in 2020's technical glitches.
Thank you all.
So true. Bye.